we've been getting a ton of questions lately about all kinds of different topics. So what I wanted to do today was do a bit of some Q&A. So let's do this. Let us get into this Q&A. So the way I want to do this format, the way that this is going to go, is I want to make sure that we talk about certain questions that have come up over and over and over and over again. And I'm fairly confident this stuff is on exam. So question number one, this question is, what is sub-agency and is it common? And these are questions from students that have come across our desks over the years. Okay, so here's the question, what is sub-agency and is it common? And let's go to the next slide. So let me give you the breakdown here. Sub-agency is a relationship between a listing agent and another agent who works to bring in buyers. The sub-agent's duties are to the seller, not the buyer. And that's sort of the critical component here, the underlying fact that we need to know. So something first and foremost is sub-agency is a legit thing. What sub-agency is it is a situation where there is a third party. So typically what most people are used to in the real estate business, I'm just going to kind of draw up here, is they're used to a seller's agent. And then on the other side of the transaction, there's a buyer's agent. All right, and then one agent will represent the seller. This is like the listing company or the seller's agency. And another one is the buyer, and the buyer is being represented by a buyer's agency. So there's a seller's agency. And by the way, they typically split the commissions when they represent the various parties. All right, so we know that there's this grouping. And what sub-agency in essence is sub-agency. What it was and it was replaced by buyer's agency. Sub-agency was a scenario where the seller was being represented by a seller's company. And then what the seller's company would do is reach out to another company and say, hey, would you happen to be able to assist us in finding buyers for our seller? And so the other company, instead of being a buyer's representative, was being retained by the seller's company to help find a buyer. So the buyers would be introduced to this company, and this company worked underneath this company that worked for the seller. So like sort of the hierarchy would be the seller, and then the seller's agency, all right, SA. And then underneath the seller's agency is this other company. I'm just going to write OC for other company. So the hierarchy was this way. And the sub-agency relationship is this. So sub-agency is where the sub-agent's duties are to the seller and not the buyer. So this was very confusing. And it's been confusing forever because in the 90s, they came up with this other alternative called buyer's agency. And buyer's agency was the allowance of real estate professionals to be able to represent buyers. And so this is one of those classic ones on exams. You see it because a lot of students don't understand this relationship. And because they don't understand it, test writers write about it because it's not outlawed. It's still allowed to be practiced. But however, it has been replaced by the buyer's agency. Now, most transactions today involve buyer's agents directly representing the buyer, or something known as dual agency, where there's one firm is representing both sides. So sub-agency is much less common than it used to be. So is it common? Way less. However, on exams, it shows up. So you want to be able to understand, and you'll find this in agency style questions. So ask yourself as you're reading these agency style questions is what is happening here? And even if you have like the ability to just draw something out, do that, and it should serve you well to try to figure out where the fiduciary obligations are lying, that a sub-agent owes that care, obedience, loyalty, disclosure, accounting, and confidentiality to the seller, not to the buyer. And the buyer in a sub-agency relationship is simply treated as a customer. So this is a classic one and a good one to review because it is relevant for real estate exams. Another question that came in is, what is the difference between a void and a voidable contract? And it's a classic question. You get it. So when you teach contracts in real estate courses or any course, law school or whatever, contracts are going to bring up these different ones. And really this one avoidable is the question that a lot of students tend to have. And so a void contract is a little bit easier to understand because there's some like sort of finality to it, right? Like it's like, okay, there's a void contract. That means that it's missing something that makes it unenforceable in court, legally unenforceable. And a voidable contract, however, is a contract that's written properly, but one or both of the parties can disaffirm or back away from their portion and render it voidable by one or both parties. So a voidable contract is one of those contracts that can confuse students. So the way it always works is there's a valid contract, there's void, and there's voidable. And when I teach it, I also like communicate, hey, listen, there's also enforceable contracts and there's unenforceable contracts. You know, obviously there's bilateral, unilateral, there's all of these different sort of variants, but that's the way that this works. Now, what is a voidable contract? So what is the difference between a void and a voidable contract? So a void contract is unenforceable and has no legal effect from the beginning. It wasn't properly written. So a contract, a classic one, is some contract for illegal activities. So there has to be this offer and an acceptance of an offer. There has to be consideration in a contract. There has to be mutual assent, meeting of the minds. There has to be for a legal purpose. So there are these elements that contracts must have. And if they are missing any of these elements, for example, if it's for an illegal purpose, well, then the contract is void. So void contracts are missing the elements, any of the elements of a valid contract. So if it's missing that, now you'll find the elements of a valid contract in your real estate books. So wherever you are studying, wherever you are learning this stuff, look in your books under contracts and you're going to find the elements of a contract. And once you find there, memorize those. And then if you play down backwards, if there's anything missing, like the illegality of a contract will come up. And if you see that, then you know that it's a void contract. Now, a voidable contract is a valid contract. So it hits all of the marks of a contract, but it can be canceled by one party due to some specific legal ground. The classic one could be fraud or misrepresentation. And the big one that you see on real estate exams is for a minor. So a minor child entering into a contract, or somebody that's mentally incapacitated or not of legal age to contract, involves themselves in a contract, and then that contract would be voidable by the minor. So the minor can back out of their portion of the contract. So it's voidable by the minor. And so void and voidable, absolutely on exams. Look out for it. All right. Another question that we got from our team, from our students, is what is the difference between joint tenancy and a tenancy in common? Joint tenancy versus a tenancy in common. Now, what both of these are co-ownership. So there's ownership in severalty or sole, and then there's co-ownership. And joint tenancy, I'll say JT, tenancy in common, TIC. There's tenancy by the entirety. Then there's community property. And co-ownership is where more than one party owns the property together. Where's all of this found? It's found in the deed. So I'm sort of asking a bit rhetorically. I'm not looking at the questions if any of you guys are asking them, but rhetorically speaking, is it possible for more than one person to own real estate? Well, the answer is yes. Can a company own real estate? The answer is yes. Can a company and a human being own real estate together? The answer is yes. Can two human beings own real estate together? Yes. Can spouses own property together? Yes. Can spouses own property separately? Yes. So all of these different variants exist. Can, three business partners own property together and they want equal ownership interest? Yes. Can you own 90% of an investment property and I own 10% of that investment property? Yes. All of our names, if we are doing business together, will show up in a document called the deed. The deed is simply a receipt to a piece of real estate. That's all a deed is. So a deed is a receipt to a piece of real estate, and that's all it is. And all of this language, joint tenancy, tenancy by the entirety, tenancy in common, tenancy in severalty, all of this stuff shows up in the deed. All right. So that's forms of ownership simply means co-ownership is that at minimum, two parties own the property concurrently together. Okay, that's what that means. So what's the difference between a joint tenancy and a tenancy in common? So in a joint tenancy, co-owners have equal shares, and there is something called a right of survivorship. Oh, you're going to see that on your exam. Meaning, if one dies, the property passes to the other co-owners. So when something has the right of survivorship, it means that the surviving co-owners get the interest when one of the co-tenants dies. So if there's A and B and they're joint tenants, which has the right of survivorship, if A passes away, A's interest in that property doesn't go to A's estate. It goes to B, and that means it has the right of survivorship. So y'all need to make sure you sort the difference between no right of survivorship and the right of survivorship. That's the trick. And if you understand that, it's a bit counterintuitive as well, but you want to just know that if it has the right of survivorship, like yes, it has it, then if one of the co-partners dies, then their interest goes to the surviving co-owner. If A and B own a property as joint tenants, and it says that in the deed with right of survivorship, if A passes away, then B now inherits all of the interest that A once held. It doesn't go to A's estate. But if an co-ownership has no right of survivorship, like a tenancy in common, see, a tenancy in common has no right of survivorship, then that means that if A passes away, A's interest goes to A's estate and A's heirs. So that's how that works. And that's critical. You need to make sure you get this. Watch this section over, and it's going to help you and serve you well, I promise. Now, an other fundamental difference is a joint tenancy will always have equal shares. So if A, B, and C want to be joint tenants and A brings all the money to the investment and B and C don't bring any money to the investment, if the deed says A, B, and C is joint tenants, then A, B, and C have an equal interest in this property. It's equal, period, regardless of who brings in all the money. But in a tenancy in common, if A, B, and C all decide to buy an investment property and A brings the lion's share of money, let's say A brings 90% of the money, B brings in 5% of the money, and C brings in the other 5%, well, then in that case, they would put on the deed A, B, and C as tenants in common, because tenants in common can have unequal shares. And that's the major difference between joint tenancy and a tenancy in common. Tenancy in commons are like common areas also in condominiums and such. And those are important to also understand. So co-ownership is important. You need to read through it. It's absolutely on real estate exams. If you're looking to pass your real estate exam in as little as 2 days, make sure to check out my best-selling 48-hour study plan. This simple 2-day schedule takes a few hours each day. So if you're taking the real estate exam this week, then this is absolutely the product for you. And guess what? It's on sale right now. I'll drop a link
in the description below. Yeah.
All right. So with agency, let's do this. First off, you want to know what agency is. And basically, agency is the relationships between the licensee and the various parties. Now, those various parties are known as clients and customers in transactions. The transaction can have multiple, two clients, client on the buy side, a client on the sell side. It could be a client on the tenant side. It could be a client on the landlord side, or both. So many states offer different types of these agency relationships. But the fundamental here is that agency relationships are between a real estate professional and their client. And there are ways that we treat the customer, okay? Where the agent acts in the client's best interest. So when we're talking about the client's best interest, well, who is the client? First off, the client is also referred to as the principal on real estate examinations. So I want you to know that the word client and the word principal can be used interchangeably on exam questions. And they'll do that. They'll twist it around many times. Many times writers try to get sneaky and they'll still call them the principal. They might call them the client. The customer is a definite different party. It's the other party that we owe certain things to, but we owe the best interest to act in the best interest of the client in agency relationships. Now, we call that acting in the client's best interest. A fancy word for that is something called fiduciary. responsibilities. I'm just going to write fiduciary relationship. Now that's really what we owe them, this thing. And we're going to break that down in just a few moments. Now, how is an agency relationship established? Classic question. There are two ways we can establish an agency relationship. One way is through express written agreement. We can be hired with formal paperwork. And another way we can do it is through implied action, sort of actions. I do something, you do something. I do something, you do something. And with that, we can establish a relationship in that format. As well, we can establish a contract in that way under certain conditions. For example, I could pay my landscaper, leave a check for them on the door. I could never meet them. I just say, hey, look, they say, hey, I'm going to cut your grass. I don't say no. They're cutting my grass. They leave a bill. I put a check where they left the bill, and we just go back and forth. They come every week. They cut my grass. I never get to talk to them. I never meet them. It's actually kind of close to the truth. And that's how this goes. Do we have a contract? Sure, absolutely. We've established some sort of a contractual obligation, and when they cut my grass and I refuse to pay, then we might have a grievance, but we have a contract, okay? All right, so let's go into this a little bit further, and we'll go from there. So let's keep going. How do this agency relationship is established? And it's established that way. All right, so we were talking earlier about how we establish these agency relationships. And the first way we can do it is through express agreement. Express agreement. This is the clearest way that we can start a relationship. It can be written or verbal, and it outlines the terms explicitly. So an example of an express agreement would be a listing agreement. Okay, so a listing agreement is an example of an express agreement. It happens to be in writing. An implied agreement, with the example that I gave you about my landscaper, occurs through actions, such as an agent showing loyalty by assisting a client informally. In the real estate practice, it could be, hey, I'm going to show you your apartment, and I show your apartment a bunch of times, and if somebody rents it, will you pay me a commission? And the landlord says, sure, I'll pay you a commission. So we have this implied agency relationship that's also happening. Obviously, the best way to create an agency relationship is through express agreement, right? That's the best way. But we can also create these implied agreements as well. So you want to know express versus implied. Now, in the world of the types of agency relationships, what we have is we have something called a general agent or general agency, and then we have something called special or limited agency. Now, these are definitely things you see on exams. And general agents are hired to handle ongoing tasks. A classic example of a general agent, there are two I will give you. Number one, a salesperson is considered a general agent. They're an agent that works under a special agent. The special agent, I want you to know for your examination, is a broker. Broker is a special agent hired to perform a single specific task. Sell my house, rent my rental unit, find me a house, find me a place to rent. These are all specific, single specific tasks. And we call those that we hire a special agent. Now you might go, hey, I found an apartment through a salesperson. They were working for a broker. Well, that's true, but the broker was hired, and then the broker delves out the authority to their general agents, the salespersons, to be able to do it. Remember, a salesperson cannot practice without being affiliated across the United States. They have to be affiliated with the broker. So, and if you want to practice as a salesperson, you have to be affiliated with the broker. There's no way to independently operate with just a salesperson's license. That's on your real estate exam, I'm pretty sure. All right, so brokers are special agents, salespersons are general agent. Another example of a general agent would be a property manager. So a property manager is also a general agent. I'm just looking over my shoulder, making sure everything's looking good. All right, so that is what is a special and general agent. The next thing let's talk about common agency relationships. And these are very standard so that we can kind of take a peek at these and understand. You're definitely need to know how to break these open a little bit. Like common agency relations that we have here is we have buyer's agents, seller's agents, and dual agents. And you want to understand basically how each one of these kind of looks and works. These are pretty simple. These two are very sort of like binary, right? Like we've got a client on one side and we've got a customer. So the hierarchy here is broker, then underneath every broker is a salesperson. Remember, the broker is the special agent. I'll write SP here, and then the salesperson is the general agent. I'll write G. That's a G right there. All right, so in a buyer's agency scenario, in this agency relationship, the client making on the other side, because we call these single agency relationships. Single agency means there is one client or one client group and one customer or one customer group. So like one side versus the other kind of thing, right? Client and the other side is customer. And in buyer's agency, the customer is the seller. All right, so we have the seller, who's the customer, or we treat them like the customer, and then the client is the buyer. And we are representing the buyer. Therefore, we owe the buyer, the client, also known as the principal, we owe them the fiduciary obligation. All right, so we owe them a fiduciary obligation. Now, for my friends all over the country, we learn fiduciary obligation in two different ways. I'm going to jump to that slide, and then we're going to come back here. We're going to fill these in. Okay, so what is a fiduciary relationship? A fiduciary relationship, or the fiduciary duties, are everything the agent does or does not do must financially benefit their principal. Everything that they do or don't do, every action that they take or don't take in a fiduciary relationship must benefit the client or the principal. And there are several of these. Absolutely, these are on examinations. You need to memorize these. One way that we can memorize them is this acronym called OLD CAR. All right, so remember, the agent must act in the best interest of the client at all times. As a matter of fact, breach of fiduciary trust is a tortious claim that somebody can allege if their agent violates any of these in some way. So obedience, loyalty, disclosure, confidentiality, accountability, and reasonable care. These all make up OLD CAR, or the fiduciary obligations or duties. Now, this is what's owed. The agent owes this to the client. So you want to remember that. Now, another way that you can remember the OLD CAR acronym in some books in some states that y'all are in, we learn it as cold AC. And in that case, we have care. So they have care here, care. Then obedience. Then we have the L is loyalty. Then we have disclosure. Then we have accounting. And so no matter which way you learn it, 6 to 1, half a dozen to the other, you want to memorize these. Now, also what you want to memorize inside of these, and this is an important one too, is you want to make sure that you understand what each of these are defined as. So go through your books and materials and sort of understand what they are. Like, what does care mean? What are we supposed to be doing? What does that simply mean? What is obedience? We have to put their interest above our interests, right? So we have to make sure that we are following that faithfully within the scope of the law, of course. If our client tells us or orders us a directive that is illegal, then we don't have to comply with that. So things like that, little bitty nuances you're going to see about these. A lot of test writers like to mess with this one. So you want to make sure that you have that under control. Okay. Loyalty is another good one. Disclosure could be paperwork, or it could be disclosing material facts and material defects. Those are also important. Accounting, we have to be accountable for all monies being held, no commingling, no conversion, that kind of stuff. And then confidentiality. In some states, confidentiality must be maintained forever. And in other states, confidentiality must be maintained until the transaction consummates or settles. And so double check with your state there. Every state is going to have some silly thing that's different about it compared to some other state. Generally speaking, this all flies throughout these general concepts. Okay, so just keep those in mind. All right, so that's fiduciary duties. All of this stuff we owe to the client. Now, what do we owe to the customer? Let's go back here. And to the customer, if we owe all of that stuff, the cold AC, I'll write OLD CAR. We owe that to the client. The customer, we owe a couple of things to. All right, so we owe sort of a professionalism, reasonable care. And again, those could be all of the following are owed to a customer, except kind of questions, those kinds of things. You want to know a little bit about those. Okay, so that's buyer's agency. And a very brief overview. Again, I'm giving you just a quick rundown. Read your books, check them out, work on some practice questions here because they do come from different angles, a lot of the test writers. Now, if this works for the buyer's agent, then a seller's agent is basically the opposite here. So if we're looking at the seller's agent, we just swap these folks out. Okay, so client becomes seller and then customer becomes buyer. And again, this is a single agency relationship, means that one side is a client, one side is a customer. We will also many times on exams and in practice refer to a seller's agent as a listing agent. Y'all want to know that? Because sometimes in questions, they'll be very distinct about the listing agent being a separate person or entity at the real estate brokerage firm, separate from other people. Now, at a real estate firm, all of these different things, generally speaking, can be practiced depending on the firm. Some firms like to exclusively represent buyers. Some like landlord representation only. Some like tenant representation only. Some like sellers representation only. And then you have your companies that'll do a little bit of everything. Somebody at their office will be listing agent. Somebody in their office will be a seller's agent. Somebody in their office will be a buyer's agent. Somebody in their office will represent landlords, blah, blah, blah. They'll go from there and they'll sort of fractionalize what they're doing. So you want to understand it all depends wherever y'all work at. You want to find out what their agency relationship practices typically are, what they will allow to be practiced inside. Some firms are very specific about we only represent buyers. Some will say we will represent sellers, etc. All right. So the dual agency is a scenario, and you want to know this. Some states allow dual agency to be practiced client, and in dual agency, both sides are treated like a client. All right. So in dual agency, there's a fiduciary obligation that's owed to both sides. Now, that is a popular one on exams because you can't give the full fiduciary trust to both sides. You can't give old car to both sides because you would be sort of competing against yourself. So instead, what they do is they limit what you have to give to both sides. So this is something that they call limited, and limited agency is you break it down to the first three are what you will avoid. Care, obedience, and loyalty, you don't owe to either side. But disclosure, accounting, and confidentiality, you can give to both sides. You can maintain confidentiality. You can be accountable for all the monies being held and moved back and forth. And you can disclose material facts, material defects about the asset, about the property. So those can all be played. And as a matter of fact, this is popular on exams. So I would look out for something like this, a test question, practice. You'll see them. I know we have a bunch of these styles on our channel. So just as you're sorting through our questions, we have a ton of questions. You should be good to go. Okay. So that's a little bit more about the dual agency. Now, a couple of other things here, and then I want to get into some of the flashcards, is types of listing agreements. So in our business, definitely, you are going to see that we have all kinds of different listing agreements. And these listing agreements are where we're representing the seller. And you definitely need to know the definitions of these. Exclusive right to sell. You want to know the difference between this and an exclusive agency, the definition of an open listing, and the definition of a net listing. Now, I'm going to circle this one. Every real estate exam makes a reference or some answer to a net listing. It's on every single one of them. It's going to be on yours. It's going to be on, you have younger generations taking the real estate exam. Generations from now, it'll be on their test as well. So net listing is a very popular thing. So let's sort of do this from the back. The net listing first is agents keep anything over the set sales price. So net listings in many states are illegal or prohibited. And that's one of the reasons why you see them. So these are not allowed. And the reason why is it could adversely impact valuation in areas because the motivation is not in alignment with the fiduciary obligation. So a seller might come to me and says, look, Dee, all I want to make is $2 million. Anything you can sell this place for above $2 million, you can keep. So I sell the asset for $2.5 million in a really hot real estate market. It's interesting, right? In certain markets, it's what two parties perceive, and it's a certain sort of a socioeconomic and financial ability and capacities. You'll see that in some areas, look, a building to two really, really rich buyers and sellers, they could say slap a price on it, and it's to whatever the buyer wants to buy it for. Really, it has less often to do with market dynamics, right? It's more to do with just buyer and seller, which is true for market dynamics. I guess you can argue, right? But the reality is, in some areas you can say, hey, I've got something that's worth 2, 3, 4, 5. It depends. I don't even know. And it's not based off of any actual number or anything like that you typically see. All right. So what you end up finding out is that the net listing can severely impact valuations in an area, and therefore they prohibit them. Now, the exclusive right to sell and the exclusive agency, you want to know the difference between these two. And then we have something called an open listing. Open listings, the seller can work with multiple agents. Whoever can first come, first serve. Whoever can rent my unit first will get the commission. That's sort of how an open listing works. Many times in areas that do a lot of rentals and get commissions for those, you'll see rental agents and landlords work with the open listing capacity. Right? You'll also see many times that the landlords will also work exclusively. And now the agents, from the agent's perspective, they want one of the two of these. They want to be exclusive no matter what, but they want to either be exclusive, including the seller, which is the exclusive right to sell. Agents get commission regardless of who finds the buyer, including the seller themselves. And then the exclusive agency commissions only if the agent finds the buyer, but the seller can sell and find their own buyer. Obviously, every agent wants the first one. And usually when they go to a listing agreement, the second contract isn't even there. It's not even an option. But for some of you sellers out there that are looking at buying and selling and et cetera, you want to make sure that you find out. Maybe you know buyers that want to buy an asset, and agents might try to throw rocks at me because of this. But the reality is that people just show up with the exclusive right to sell. They don't even think that there's something else, and there's always something else. Everything, 100% of everything here that we're learning in the business is negotiable. Commissions included, by the way. All right, so those are your different types of listing contracts. Look out for those. What else do we have here? I want to also just point out that when we're dealing with other brokerage relationships, there is this other non-agency relationship called a facilitator. And in some states, y'all call them transaction brokers. Facilitators and transaction brokers are basically where there is no specific client representation. So there is no client. Both sides are customers. And the agent is representing the transaction, not the sides. So there's no fiduciary obligation. However, there are some very limited things that you owe as a facilitator. You still owe disclosure and you still owe accounting. So these are two fiduciary obligations that are still required of a facilitator. Now, many times you'll see agencies act as facilitators on larger scale transactions. If some large multinational company or international company they have their own real estate team. They don't need a brokerage firm to negotiate on their behalf. They need to understand the customs and practices of the area, but beyond that, they don't really need to know much more than that. And you might be dealing with a huge, real estate investment trust that has a large portfolio of properties that deal in those spaces. And so they have their professionals. Facilitators are kind of bringing parties together, and they get compensated for such. But they only owe both sides the treatment of customers. Okay? So we talked about the customer relationship. We talked about fiduciary obligation. We talked about the different elements here. The thing I also want to talk about is terminating these relationships. So how do we terminate agency style relationships? And they're fairly easy to terminate. Number one, it could just simply expire. The listing is over at the end of the summer. If you can't sell my house, then the listing contract expires. The best way that we can expire or terminate a contract is the fulfillment of this contract. The deal closes. Everybody gets paid. Everybody goes on their own way. Mutual agreement. Hey, agent, this isn't working out for me. Agent says, I agree. This isn't working out for me either. Let's terminate. Let's agree to disagree, right? That's mutual agreement. Breach of contract. Breach is a violation. And so the seller could sue the agency for breach of contract, or lack of fiduciary trust, these types of things. Breach is where somebody violates in a contractual obligation, and there are certain remedies. There could be money damages, there could be just termination of the agreement, and so on. Now, also, death or incapacity of the principal or the principal broker. In many instances, would terminate unless a specific language to the contrary would they allow that to happen. So the death of the seller of the property would terminate the listing agreement. Now, the estate can hire the firm and continue on, but the death or incapacity of the principal would also be grounds for termination of an agency. And now they love to put termination questions equally on this. They could be all of the following would terminate a listing agreement except kind of a question. So look out for those as well. Hey everybody, Dee here, and I've got some amazing news. My premium practice exam course is available right
now. Now, this used to only be available with my high ticket course, but now you can get it on its own. You get basically my best 200 practice questions with video explanations, and I've got to tell you something, this has been one of those super popular resources for my private tutoring groups all the time. I'll drop a link in the description below so you can check it out on your own.
All right, we are back. So let's go into some questions. Let's hit these and let's get you back to your lives. Question number 1. Which of the following is not a fiduciary duty that an agent exclusively owes to their client? Letter A, loyalty. Letter B, disclosure. Letter C, honesty. Letter D, confidentiality. Which of the following is not a fiduciary duty that an agent exclusively owes to their client? Answer, letter C, honesty. All right, so honesty, remember, is what we owe to the customer, and to the client, we do not have this honesty tab. It's not part of old car, it's not part of cold AC. So we just want to remember that honesty is what we owe to the customer, and the rest is what we owe to the client. Question number 2. In which type of agency relationship does the agent have the broadest authority to act on behalf of the client? Letter A, special agency. Letter B, general agency. Letter C, dual agency. Letter D, non-agency. In which type of agency relationship does the agent have the broadest authority to act on behalf of the client? And the answer? Letter B, general agency. So with general agency, remember, that's broad allowances. Special agent is a specific task. Dual agency is something different. This is giving representation to both sides. And then non-agency is a facilitator. So again, these are classic style questions that they're going to approach you with. This would be a good way that the test writer would come at you with this kind of a topic. Question number 3. Which of the following scenarios would result in the termination of an agency relationship? Letter A, fulfillment of the contract's purpose. Letter B, death of the principal or agent. Letter C, mutual agreement between the agent and the principal. Letter D, all of the above. Which of the following scenarios would result in the termination of agency relationships? And the answer? Letter D, all of the above. So if we fulfill the contract's purpose, if there's death of the principal or the agent, the principal agent, or if there's a mutual agreement between the parties, all of these would terminate. So this is a classic way that a writer would want to write about the termination of agency style questions. Classic. You want to make sure you learn these or rewatch these parts when it comes to these questions. They're pretty sort of insightful when you think about what's going to be coming up. Question number 4. What is the primary difference between a client and a customer? Letter A. Clients are owed fiduciary duties while customers are generally owed only honesty and fairness. Letter B. Customers must sign an agency agreement, but clients do not. Letter C. Clients are represented by a transaction broker while customers are not. Letter D, an agent owes a wider range of fiduciary duties to a customer compared to a client. What is the primary difference between a client and a customer? And the answer? Letter A, clients are owed fiduciary duties while customers are owed only honesty and fairness. Just defining what is a client, what do we owe them, and what is a customer, what do we owe them. Very, very classic, but want to make sure that you understand this type of thing. Another way that you could do this is by reading the answers first. Always read the answers if you get an opportunity. Sometimes you can sort through the answers and you can kind of see which one makes the most sense, which is true, which is false, which is partially true, etc. And here you could go through these and go, okay, this is sort of switching the roles on what client and customer is. However, letter A is the definition, is accurately describing what's going on. And the final question, question number 5. A seller signs an open listing agreement with multiple brokers to sell their property and also retains the right to sell the property on their own. If broker A and broker B both show the property to potential buyers and broker B finds a buyer who decides to purchase the property, who is owed a commission? Letter A, broker A. Letter B, broker B. Letter C, both brokers A and B. Letter D, neither of the brokers. A seller signs an open listing agreement with multiple brokers to sell their property and also retain the rights to sell the property on their own. If broker A and broker B both show the property to potential buyers and broker B finds a buyer who decides to purchase the property, who is owed a commission? And the answer? Letter B, broker B. So in this scenario, we have an open listing. It says, signs an open listing agreement with multiple brokers. And so open listing basically means first come, first served. The party that ends up selling it gets paid. The seller in this question retained the right to also sell the asset, like you have in some scenarios with exclusive agency versus exclusive right to sell. We talked about those earlier. So you want to definitely know the definitions of all of the listing agreements. You will see them. They like to jumble them up like this. They like to give you confusion. Sometimes a student might say neither. Some students might say, just one or maybe both should get paid. Not sure. And in this particular situation with an open listing, it's all about who procured cause, who created the chain of events that ultimately led to the deal closing. All right, there you go. A quick, succinct agency study session. We learned about some agency points. We looked at some vocab phrases and we hit some questions. I'd say that that's a wrap. Honestly, thank you again for subscribing and checking out our content and letting other people know our channel is growing and growing and growing, and we owe it all to you.